If you are 65 or older and you own a firearm, what I'm about to tell you could save your Second Amendment rights, keep you out of legal trouble, and make sure you never accidentally become a prohibited person. Because here is the truth that almost nobody is talking about. There are real, legal protections and real specific exemptions that apply to millions of senior gun owners in America right now. Retired law enforcement, honorably discharged veterans, senior citizens in constitutional carry states, people who have been wrongly reported to federal background check databases. The rules are different for you than for a 25-year-old first-time gun buyer. And if you don't know what those rules are, you could lose rights you don't even know you still have. Or worse, you could unknowingly give them up. Are you subscribed? Because what I am about to break down could be the most important gun rights information you've heard in years. Hit that subscribe button right now because these protections exist today, seniors are already using them, and most people have absolutely no idea. Let me start by setting the record straight. There is no single federal law that says everyone over the age of 65 is blanket exempt from all new carrying laws. Anyone who tells you that without any qualification is oversimplifying. But here is what is absolutely true. Millions of American seniors fall into specific legal categories that do provide real protections and real exemptions from the carrying restrictions and training requirements that affect younger gun owners. And those categories apply to an enormous percentage of people over 65. Veterans, retired law enforcement, seniors in constitutional carry states, people whose gun rights were wrongly stripped by a bureaucratic error. Understanding which of these categories applies to you is the difference between knowing your rights and accidentally violating the law. So let's break it all down. Let's start with the biggest story affecting senior gun owners in 2025 and 2026. Because this one is massive and it received almost no mainstream coverage. For decades, the Department of Veterans Affairs had been secretly reporting thousands of veterans to the federal background check system as mentally incompetent, not because a judge ruled they were dangerous, not because they had been convicted of any crime, not because any court made any finding about their mental health, simply because the VA had appointed someone else to help them manage their VA benefit payments. A financial arrangement, a paperwork decision. And that paperwork decision was being used to strip veterans of their Second Amendment rights. Veterans who served this country, veterans who sacrificed years of their lives. Some of them had severe PTSD, some had physical injuries, some had memory problems from combat. And without any judicial process, the VA was feeding their names into the National Instant Criminal Background Check System, the NICS database, as mentally defective prohibited persons, prohibited from buying, owning, or possessing firearms, for life. Think about what that means. An 82-year-old Navy veteran in Maryland who needs a little help managing his benefit checks goes to the VA for assistance. The VA assigns a fiduciary to handle the paperwork. Standard procedure. And suddenly that veteran is a prohibited person. He can no longer legally own the handgun he's kept in his home for 40 years. He doesn't get a letter. He doesn't get a court hearing. He doesn't get to present his case to a judge. He finds out when he goes to buy a firearm and gets denied. Or worse, he finds out when law enforcement shows up because someone realized he still has a gun. This was happening to thousands of veterans, and most of them had no idea it was legal or how to fight it. If you're finding this important so far, and I know you are, please subscribe right now, because I cover stories like this every single week, and most mainstream news outlets ignore them completely. I don't want you or anyone you love to be the last to know about something that affects your constitutional rights. Hit that button. Now here's where the good news comes in. In November 2025, Congress acted. A federal appropriations package was passed that included a critical provision. It specifically prohibits the Department of Veterans Affairs from stripping a veteran's Second Amendment rights simply because they have been appointed a fiduciary to manage their benefits. Without due process, without a judicial determination, without a court finding that they are actually dangerous. The VA must now go through a proper legal process before reporting a veteran to NICS. That means a judge or a quasi-judicial body has to make a real finding that the veteran poses a genuine danger. Just needing help with your benefit paperwork is not enough. This is a massive win for senior veterans. And it gets better. In February 2026, the VA went even further. The Department of Veterans Affairs announced it was halting the reporting of veterans who have fiduciaries to the NICS database entirely. Officials reviewed the legal standard and determined that the VA's own internal decision to appoint a fiduciary, quote, falls short of the legal standard required to report someone as prohibited. That standard requires a judge or quasi-judicial body to make a determination of mental incompetence. The VA's administrative process does not meet that bar, so the VA stopped. Veterans who were wrongly reported are now beginning to have their rights restored. And pending legislation including Senate Bill 478, the Veterans Second Amendment Protection Act, would make this protection permanent in law rather than just policy. What does this mean for you as a senior veteran? If you were ever reported to NICS by the VA because you were assigned a fiduciary, you may be wrongly listed as a prohibited person. Your gun rights may have been stripped without any legal justification. And under the new policy, you may have a path to having those rights restored. Here is what you should do immediately. Contact the VA directly and ask whether your name was reported to NICS. You have a right to know. Second, contact a veteran service organization like the American Legion, the VFW, or the DAV. They have legal resources and advocates who can help you navigate this. Third, if you believe you were wrongly reported, consult with an attorney who specializes in firearms law and veterans' rights. The process for getting your name removed from NICS is called a relief from disability application, and it is a real legal process that works. Now let's talk about another huge category of senior gun owners who have exemptions that most people don't know about. Retired law enforcement officers. If you served as a police officer, sheriff's deputy, federal agent, or other qualified law enforcement officer and you retired in good standing, you likely qualify for one of the most powerful gun rights protections in federal law. It is called the Law Enforcement Officers Safety Act. Most people know it by its shorthand, LEOSA, or its bill number, HR 218. Here's what it does. Under LEOSA, qualified retired law enforcement officers may carry a concealed firearm in all 50 states and the District of Columbia, not just in their home state. All 50 states. Even in states like California, New York, Illinois, Massachusetts, and New Jersey that have some of the most restrictive concealed carry laws in the country. LEOSA supersedes all of those state laws. It is a federal right. Let me explain who qualifies. A qualified retired law enforcement officer under LEOSA is someone who separated from service in good standing from a public agency as a law enforcement officer. They must have been authorized by their agency to carry a firearm in their last year of service. They must not be under any felony indictment, have been convicted of certain crimes, be a fugitive, or otherwise be prohibited from possessing firearms under federal law. And they must meet the firearms qualification standards for active law enforcement in their state at least once a year. That last requirement is important. You cannot simply carry under LEOSA indefinitely without maintaining your qualification. You need annual qualification from either your former agency, another law enforcement agency, a certified firearms instructor, or a state-certified instructor. Many retired officers get this done at ranges that offer law enforcement qualification testing. The cost is typically modest compared to what civilians pay for concealed carry training, and once you're qualified, you carry anywhere in America. The documentation you need to carry under LEOSA is a photographic identification that identifies you as a retired law enforcement officer, and either a certification from your former agency or a certification from a licensed firearms instructor indicating you met the qualification standards within the past year. If you're a retired law enforcement officer and you've never looked into LEOSA, do it today. You may have been paying for concealed carry permits and training that you didn't need. You may have been limiting yourself to carrying only in states that honor your home state's permit when you could legally carry in all 50. Know your rights. Quick legal note. This is educational information, not legal advice. The specific requirements of LEOSA are detailed, and you should confirm your eligibility with an attorney and with your former agency before relying on LEOSA as the basis for your carry right. Now let's talk about something that has quietly transformed gun rights for senior Americans over the past few years. Constitutional carry, also called permitless carry. As of 2026, 29 states have adopted constitutional carry laws. These laws allow any person who can legally possess a firearm to carry it concealed or openly without obtaining a permit. No training course required, no application fee, No wait, no bureaucratic approval process, just your constitutional right, exercised freely. Those 29 states include Alabama, Alaska, Arizona, Arkansas, Florida, Georgia, Idaho, Indiana, Iowa, Kansas, Kentucky, Maine, Mississippi, Missouri, Montana, Nebraska, New Hampshire, North Dakota, Ohio, Oklahoma, South Dakota, Tennessee, Texas, Utah, Vermont, West Virginia, Wyoming, and Louisiana. Here is why constitutional carry is particularly significant for seniors. Let me be specific. New gun-carrying laws in states that require permits have been getting increasingly burdensome. Colorado, for example, effective July 1st, 2025, now requires an 8-hour in-person training class with a live fire qualification where you must score at least 70% to get your concealed carry permit. Online-only classes are no longer accepted. That requirement is real. It costs money. It requires physical presence at a range. It requires a level of physical performance. And for seniors with mobility limitations, arthritis, vision problems, or other age-related challenges, completing a range qualification can be genuinely difficult. In states like New York, the training requirement is 18 hours. In some jurisdictions, the permit process takes 6 months to a year. If you live in a constitutional carry state, none of that applies to you. If you live in a state that has recently expanded its constitutional carry provisions, you may be exempt from training requirements that apply in other states. If you live in a constitutional carry state and you've been holding back from carrying because you thought you needed a permit, you may not. Check your state law, confirm with a local attorney. But in 29 states, you have the right to carry without a permit today. And that is a real legal protection that applies to millions of senior Americans. Hey, 73% of people watching right now are not subscribed. Don't be in that group. The senior gun owners who watch this channel stay informed, they know their rights, and they protect themselves and their families. Click subscribe right now and join the community. Now let me talk about something that should concern every senior gun owner in America. Red flag laws. These are also called Extreme Risk Protection Orders, or ERPOs. As of 2026, more than 20 states and the District of Columbia have red flag laws, and these laws create a specific and serious risk for senior citizens. Here is how they work. Under most red flag laws, certain people can go to court and petition a judge to issue an order temporarily removing your firearms and prohibiting you from purchasing new ones. Who can petition? Depending on the state, it can be law enforcement, a family member, a household member, or in some states, a healthcare provider. The petition is often heard without you present. In emergency situations, the order can be granted within hours. Your guns can be removed before you even know a petition was filed. Here is why this is a particular danger for seniors. Think about the situations that can trigger an ERPO petition involving an elderly person. A senior with early-stage dementia makes a confused statement that a family member misinterprets as threatening. An older adult who lives alone expresses frustration about loneliness or health, and a well-meaning but overreacting family member files a petition. A senior who is going through grief after losing a spouse makes emotional statements that trigger concern. A healthcare provider who sees a senior with depression reports it to authorities. A neighbor calls for a wellness check after not seeing an elderly person for a few days. None of these scenarios involve actual danger. None involve someone who is genuinely a threat to others. But all of them can result in an ERPO petition being filed. And once that petition reaches a judge, the bar for issuing an emergency order is relatively low. Courts tend to err on the side of caution. They grant the order. Your firearms are removed. And here's the part that almost never gets mentioned. Getting your firearms back after an ERPO is hard. You have to attend a hearing. You have to present evidence that you don't pose a risk. You may need an attorney. The process can take weeks or months. During that time, you are vulnerable. The very reason you had a firearm to protect yourself is gone, and the legal fees to fight an ERPO can be substantial. There are also cases where seniors are not even notified of the petition before the order is issued. They come home to police at the door. Their firearms are taken, and they are handed a court date. For an elderly person living alone, this process can be traumatic. And studies show that red flag laws in some states are disproportionately applied to elderly individuals, particularly those with dementia or depression. What can you do to protect yourself? First, be mindful of your words. In the era of red flag laws, statements made in frustration, grief, or emotional distress can be taken out of context and used to justify a petition. This is not about suppressing your emotions. It is about being aware that the legal landscape has changed. Second, talk to your family. If your family members understand that a red flag petition could take away your means of self-defense and put you through a traumatic legal process, they may think twice before filing one. Communication about your mental state, your reasons for owning firearms, and your competence can prevent misunderstandings from becoming legal crises. Third, keep documentation of your fitness. If you have seen a doctor who can speak to your mental competence, that documentation can be invaluable in fighting an ERPO. Routine wellness checks, records showing cognitive health, and consistent engagement with healthcare are all protective. Fourth, know the specific rules in your state. Some states have narrower ERPO laws. Some require more than others before a court grants an emergency order. Knowing your state's specific standard helps you understand your risk. Fifth, consult an attorney before a crisis happens. Having a relationship with a firearms attorney means that if an ERPO petition is ever filed against you, you can call that attorney immediately and have representation at the hearing. Being unprepared at that hearing is when bad outcomes happen. Now, let me address another issue that affects many senior gun owners specifically: physical and medical considerations and their legal implications. This is delicate but important. As we age, certain medical conditions can legally affect our right to possess firearms. Here is what seniors need to know. Under federal law, a person adjudicated as a mental defective or committed to a mental institution is prohibited from possessing firearms. That's federal law under 18 U.S.C. 922. The key word is adjudicated. This requires a legal finding, not just a doctor's diagnosis. If you are diagnosed with depression, anxiety, or early cognitive decline by your physician, that alone does not make you a prohibited person under federal law. Diagnosis is not adjudication. However, if a court formally finds you mentally incompetent, that can affect your gun rights. This is why some seniors worry about formal guardianship or conservatorship proceedings. If a court appoints a guardian for you with a finding of mental incompetency, that could trigger the federal prohibition. This does not mean you should avoid necessary medical care or legal arrangements. It means you should be aware of the distinction between informal help and formal legal incompetency findings. If you are setting up your estate, considering trusts, or making arrangements for assistance with your affairs, talk to an attorney about how those arrangements are structured. A properly structured trust or power of attorney does not necessarily involve a formal incompetency finding that would affect your gun rights. The VA fiduciary issue was about an internal administrative process that was being improperly used as if it were a legal determination. The new protections Congress passed address exactly that improper practice, but formal court-ordered guardianship with a finding of incompetency is a different matter. Get legal advice before entering into those arrangements if preserving your gun rights is important to you. Let me also address an important aspect of the self-defense picture for seniors, because there is a legal principle that is especially relevant to older Americans. The concept of the reasonable person standard in self-defense cases takes into account the specific characteristics and vulnerabilities of the person involved. Courts have consistently recognized that a 70-year-old person who weighs 130 pounds and has arthritis faces a different threat level from an aggressive physical attacker than a healthy 25-year-old would. What would be a reasonable response to a perceived threat can differ based on the defender's physical capabilities and vulnerabilities. This is not a formal legal exemption in the traditional sense, but it is a factor that is recognized in self-defense law. Defense attorneys regularly argue that a senior citizen who reasonably feared for their life and used a firearm to defend themselves was acting within their legal right precisely because of their diminished physical ability to defend themselves by other means. Your age and physical condition are relevant to self-defense analysis. This connects to Castle Doctrine and Stand Your Ground laws. Castle Doctrine says you have no duty to retreat from your own home if you face a threat. Stand Your Ground laws, which exist in many states, say you have no duty to retreat even outside your home if you have a legal right to be where you are and you reasonably believe you face a threat of death or serious bodily harm. Both of these doctrines are particularly important for seniors. An elderly person who cannot physically run from an attacker has no realistic retreat option. The law recognizes this. Castle Doctrine and Stand Your Ground laws were designed for exactly this kind of situation. Know your state's laws on both. Know whether you are in a stand your ground state. Know the exact standard your state uses. And if you ever have to use a firearm in self-defense, call an attorney before saying anything to police. This is essential regardless of your age, but it becomes even more important for seniors who may be flustered or confused in the aftermath of a traumatic incident. Now let me talk about what I call the training requirement gap and why it matters for seniors. Several states have significantly increased their concealed carry training requirements in recent years. Colorado went to 8 hours in person with live fire. New York requires 18 hours. California's process is extremely burdensome. These requirements create a real barrier for seniors. 8 hours is a long day of standing and shooting. Arthritis can make it painful. Vision problems can affect scoring. Physical stamina may be an issue. And the costs, often $300 to $600 for a training course, can be significant for someone on a fixed Social Security income. Here is what seniors need to know about exemptions from these training requirements. First, if you live in a constitutional carry state, you don't need a permit and therefore don't need the training. Full stop. Second, if you are a retired law enforcement officer, LEOSA may give you a federal carry right that does not require state permit training. Third, if you are a military veteran, many states have reduced or waived training requirements for honorably discharged veterans. Arkansas specifically allows honorably discharged veterans to carry without a permit. Georgia allows veterans 18 and older to carry without a permit. Indiana, which adopted constitutional carry, allows anyone who can legally possess a firearm to carry without a permit. South Carolina allows active duty military to skip all training for a carry permit. Retired military in many states can have training requirements significantly reduced because their military service constitutes equivalent firearms training. Fourth, some states have age-related reduced fee programs for concealed carry permits, though specific age-based exemptions from training requirements are less common at the state level. The real story is that the combination of constitutional carry expansion, veterans exemptions, and LEOSA collectively means that a very large percentage of senior gun owners, particularly veterans and retired law enforcement, have more options than they realize for legally carrying firearms without going through the burdensome permit and training processes that apply to the general public. Let me give you a practical summary of what you need to know based on your specific situation as a senior gun owner. If you are a senior veteran, first check whether you were wrongly reported to NICS by the VA. Contact the VA and your veteran service organization. Second, if you are in a constitutional carry state, you may not need a permit. Third, many states waive or reduce permit training requirements for veterans because of your military firearms training. Fourth, fight for your rights under the new VA Fiduciary Protections and Support S.478, the Veterans Second Amendment Protection Act. If you are a retired law enforcement officer, look into LEOSA immediately if you have not already. Get your annual qualification. Carry your ID and qualification documentation. You have a federal right to carry in all 50 states. Use it. If you are a senior in a constitutional carry state, verify your state's current laws. You may be able to carry without a permit, without a training course, and without a fee. Your right to self-defense does not expire with age. If you are a senior in a restrictive gun state like California, New York, Illinois, or Massachusetts, you face the most challenging environment, but you are not without options. Check whether your state's laws have been challenged in court following the Bruin decision. In January 2026, California's open carry ban was struck down. Other restrictions are being challenged. Know the current state of the law in your state and connect with local gun rights organizations that are fighting these restrictions. Regardless of where you live, be aware of red flag law risks. Talk to your family, document your competence, have an attorney's contact information ready, and be thoughtful about what you say and how you say it in the current legal environment. Let me also address something that often comes up with senior gun owners: storage and access. As seniors age, there are real questions about how to balance quick access to a firearm for self-defense with safe storage, especially if grandchildren visit, or there are concerns about cognitive decline. Modern biometric safes are an excellent solution. They open in seconds with your fingerprint, but remain secure against unauthorized access. Gun locks on unloaded firearms are another option. The key is finding the right balance for your specific situation. Do not let storage requirements prevent you from having reasonable access to a firearm in an emergency. A gun locked in a safe on the other side of the house is not a realistic self-defense option. A gun in a quick-access biometric safe in your nightstand is. Think through your actual self-defense needs and design your storage accordingly. Here is something that also matters enormously to seniors. The Reciprocity Act, Senate Bill 65 and House Resolution 38, the Constitutional Concealed Carry Reciprocity Act of 2025, is pending in Congress. If this bill passes, it would allow anyone with a valid concealed carry permit from their home state to carry in any other state that allows concealed carry. This would be transformative for seniors who travel, visit family in different states, or spend winters in warmer climates. Right now, if you are a permit holder in Texas and you spend the winter in Florida, Florida recognizes your Texas permit. But if you spend the winter in a state that doesn't recognize your permit, you're stuck. The Reciprocity Act would fix that. Contact your congressional representatives and tell them to support this legislation. It will specifically benefit senior gun owners who travel or move between states. Let me close with this. If you are a senior gun owner in America, you have more going for you legally than you probably realize. Veterans whose rights were wrongly stripped are getting them back. Retired law enforcement can carry in all 50 states under LEOSA. Constitutional carry covers 29 states, and the trend is expanding. The Supreme Court's Bruin decision is being used to strike down the most burdensome restrictions in the most anti-gun states. Self-defense law recognizes the unique vulnerabilities of seniors, and the political momentum is on the side of expanding, not restricting, the rights of law-abiding gun owners. But you need to know your specific rights. You need to know which category you fall into. And you need to stay informed as these laws continue to evolve. The risks are also real. Red flag laws can be used against seniors who are going through difficult times. Cognitive decline can create legal complications around firearm possession. Improper government reporting can strip rights without due process. These threats require vigilance, but they can be navigated with knowledge and preparation. Subscribe now because my next video covers the specific steps every senior gun owner needs to take before the end of 2026 to make sure their firearms are protected, their rights are secure, and their family knows exactly what to do if their gun rights are ever challenged. If this video helped you understand the real legal landscape for senior gun owners, share it with every senior you know. Most of them don't know any of this, and knowing it could make all the difference. Stay informed, stay protected, and stay safe. And please remember, this is educational content only. For your specific legal situation, always consult a qualified attorney who knows the gun laws in your state. Your rights are worth protecting. Make sure you know how.